Welcome to the ARPA Benefits Compliance Updates and FAQ for our third session. Thank you all for joining us today. Our benefits compliance team will be moderating today's call, led by Diane Cross. At the end of the call, please post your questions in the Q&A as opposed to the chat. We will try to get to as many Q&As as we can in the time allotted after the main discussion. As you may have seen in our communications, we will be extending today's session to 1.5 hours to ensure that we cover all of the material. If you are unable to stay on the call, please note that today's presentation is being recorded and will be emailed tomorrow. The recording and the slide deck from this webinar will be posted to the nfp.com latest insights page under the webinars/training section. At this time, I'd like to introduce our speakers for today's webinar. Joining us today are Jill Brooking, Vice President, and Patrick Myers, Vice President and Counsel from NFP's Benefits Compliance Department. We are very excited to have them speaking with us today, and it is my great pleasure to turn the call over to our speakers. Jill, the floor is yours.
Thanks, Leanne. This is Jill. I'm going to go ahead and apologize now if my voice is kind of allergy season is here. And thanks everyone for showing up today. Glad to see there's still interest in the topic. And today we're going to present the material in a little different way. So even if you have attended the previous sessions, I think it's still good to hear it again. And in a different way, you might pick up on something different, and you may have missed some clarifications from earlier. So let's go ahead and get started. First, we have our disclaimer, of course, and especially with this topic, with laws and guidance changing so quickly, and that often happens with new administration. We do want to say that it is current as of today, the first half of the day, because after we get off this call, we could get new guidance. And so as of today, we're switching it up a little bit today, and we're going to do FFCRA leave and DCAPs first. They have been at the end of our presentations, and those of you who have only been able to stay with us for an hour may have missed those updates. So we're going to do those first, and then Cobra, the main event, will be at the end, because we know that's where the majority of questions are. So let's start off with FFCRA leave, and as the agenda and the title indicate, we're going to do this as a step-by-step guide today, kind of breaking it down, because taking the whole thing in totality can be overwhelming. So we're going to break it down step by step on what you need to do to comply on each thing. So let's start off with FFCRA leave. But first, for all of my 80s babies out there, 80s lovers, NKOTB, New Kids on the Block. So if I accomplish anything, I hope by the end of this presentation, you are singing step by step. So what was step one? Step one, we can have lots of fun. So hopefully this compliance presentation will be fun. We have to keep it interesting. So step one in this case is understand your options. So your options under FFCRA leave, the basics. Remember, this has been in place since last year and applies to employers with less than 500 employees. It was required for employers in that bucket from March 1st, 2020 through December 31st, 2020. Optional started January 1st, 2021, and it remains optional for employers through September 30th. It provides employees with paid leave for reasons related to COVID. And so remember, there's two different types of leave. There's the emergency paid sick leave, which you'll see in future slides, EPSL. We love those acronyms. And that's up to 80 hours. And then the second type is expanded FMLA. So the expanded FMLA was 12 weeks always, but the first 2 weeks were not paid. And effective April 1, they will be paid, but we'll cover that on the next slide. And just a reminder, if you're going to do this, because it's now optional, it's 2/3 normal pay up to $200 per day for childcare related reasons. and it's the normal rate of pay up to $511 for all other reasons. So these are the changes because of ARPA, the American Rescue Plan Act, ARPA. 2 weeks, 80 hours, reset on April 1st. So if you had employees that took their 80 hours or their 2 weeks of emergency paid sick leave in 2020, it resets April 1st. The first 2 weeks, as I mentioned, of expanded FMLA are now paid. And then the reasons for emergency paid sick leave and expanded FMLA leave have changed effective April 1st because of ARPA. So the text in black, those were existing reasons under FFCRA. The ones in blue are new. So basically, those related to obtaining the vaccine, an injury, disability, illness related to receiving the vaccine, seeking or awaiting results of a test, a COVID test. Very importantly, I want to point out that previously expanded FMLA was only for childcare reasons, that caring for a child whose school or place of care is closed. It is now all of these reasons. So you could have someone on expanded FMLA if they themselves are sick because of COVID. Now, you can, let's do some options here. So you could offer emergency paid sick leave, but not expanded FMLA, or vice versa. You could do one or the other. You could offer it for a period of time shorter than January through September. We had some employers that didn't do it first quarter. Maybe now you're deciding, hey, this thing's not over. We're going to do it for second quarter. You could do that. You can offer one or the other, and you have options on the duration, but you could not say, I'm going to offer expanded FMLA, but only for the child care. If you do it, you have to comply with the whole thing. So if you're going to do expanded FMLA, then you would have to do it for all of these reasons. You couldn't limit a person's reasons for doing it. Or you could say, you know what, I'm not going to do any of it. And that's your choice. But if you go with, I'm not going to do FFCRA at all, there are state considerations, which takes us into step 2. Consider state and local requirements. So while FFCRA leave, federal may be optional for an employer, many states, counties, cities, they've adopted their own version of COVID-19 leave laws, and these are not going to be optional. These are required, employer mandated. It varies on the size of employer that has to do it, how much leave you have to give them, and the effective dates. Specifically, I want to point out California, SB 95, because we got a lot of questions on that last time. And then California also has many local. Hopefully you're reading our compliance corner, and you'll notice in there that there were lots of city and county updates in the last edition. DC and New York also have their own COVID-19 paid leave laws for employers. So how do they interact together? So for California, that was a big question we received last week. If I have to do paid leave, because California is 26 or more employees. So if I have to do California paid leave for COVID reasons, how does that interact with FFCRA? Well, you don't have to do FFCRA, but if the leave would qualify under both, then you could count it concurrently and say, okay, we're doing FFCRA optionally, it qualifies for both, and then you could claim the tax credit on FFCRA for federal. I do want to point out our state COVID-19 guide. Bethany on our team, she updates this every single week. And so where you see the bright green stars on the list, on the left column, those indicate leave laws for each state. So that is on the main page of nfp.com under Insights, and that is public. So you wouldn't need a password to grab that reference chart. Now we're on to step 3, communicate to the employees. So if you're going to do FFCRA during this optional period, remember there is that poster, and we are going to send out these slides, so you will get these links that are in the slides. And then for your local leaves, they too may have notice requirements, so be sure to check your state and local agencies for any of those notice requirements. It's going to be in Compliance Corner too. And communicate proactively rather than only informing those that ask. So if an employee, you know they're out for COVID, it's like, oh yeah, we have this leave. No, you may not know why someone is taking their PTO. Maybe, they told their manager and the manager doesn't know anything about FFCRA. If you're going to do it, communicate proactively that this is available, and then update your leave policies as necessary. And then step 4 is going to be your payroll practices. And so there's Newman over there doing his payroll. I don't know if I would trust him to do mine, but consider changes that need to be made to your HRIS or payroll system, because if you're doing FFCRA or your state leave, you're required to, you need to code that in a way that you'll be able to run reports on that data later. And so especially if you're doing the federal, you want to claim that credit. So you'll have to know which employees and how much you spent on those wages. And then you'll also need to report that on Form W-2. If it's going to be the same as 2020 Forms W-2, that had to be reported in that free form box of box 14, where you just say what the other compensation is. And I want to point out there in blue a very important point, that in 2020 and under the previous iteration of FFCRA, tax exempt governmental entities, actually I should have clarified that, governmental entities such as municipalities, fire departments, they were required in 2020 to offer the FFCRA, but they couldn't take the tax credit for it. Now, effective April 1st with Arpa, those entities can claim the tax credit for FFCRA if they're doing that. And that's it for FFCRA. Do we have any questions, Diane?
Yeah, Jill. First of all, I think a lot of people appreciated your singing and the references.
Thank you.
So thanks for that. There have been a few iterations on the timeline, that the 12-week requirement generally for FMLA. So the question we received is if the EFMLA counts against the employee's regular FMLA allotment now that it's optional. So, and another way we received this question is, are we getting 12 weeks in addition to the 12 weeks of regular, if you will, FMLA? Do you want to address that, or I'm happy to? Okay.
Great. Yeah, let me try, and then you can add in your thoughts. So
okay.
It does not give them a different bank. It does expand the reasons under existing FMLA. It's a little confusing because existing FMLA only applies to employers with 50 or more employees. And then this, of course, applies to smaller employees as well. So it's a little confusing, but it is the same bank. They don't get additional FMLA time. The difference is, so let's say I have my own COVID illness and I have contracted related medical conditions because of it, and I'm out a very long time. In 2020, that wasn't a reason under FFCRA expanded FMLA. I got the 2 weeks of emergency paid sick leave, but then I could always take FMLA if my employer is subject to it because it's my own illness. That's the reason I can't work. So I was able to take unpaid FMLA, but now effective April 1st, ARPA, as it changes FFCRA, for my own illness, I could receive payment for that time. I could get my normal rate of pay up to $511, but that goes concurrently, same time as regular FMLA. This just gives them payment for it.
Yeah, I completely agree and have nothing else to add there. Thank you.
You concur.
I concur.
That is from one of my favorite movies, Catch Me If You Can. I concur.
Yep.
You concur. I concur. Okay, Patrick, take us into decaps.
Thank you, Jill. Well, speaking of the 80s, I can't say how many of us are hungry like the wolf for our information on ARPA's changes to decaps. But in the few minutes I'll be discussing it, we're going to whip it good. And by the time we're done with it, don't you forget about it. So if you can please go to the next slide. Our first step for ARPA changes to decaps is to understand what our options are. You can go to the next slide, please. As you know, under normal circumstances, a participant's decap reimbursement amount is generally limited to $5,000 if the employee is married and filing a joint return, or if the employee is a single parent, and it's half that when the employee is married and filing separately. But ARPA has changed it so that there's a temporary increase to that limit up to $10,500, or half of that as appropriate, for the taxable years beginning after December 31st, 2020 and before January 1st, 2022, basically for the calendar year 2021. Now, ARPA appears to allow employers to permit employees to increase their 2021 decap election limit up to $10,500. If they choose to do that and permit mid-year election changes pursuant to the Consolidated Appropriations Act, it appears that participants can then contribute up to $10,500 for the 2021 calendar year. Note, however, that if an employer chooses to increase the decap contribution limit to that amount, and they also permit a carryover or a grace period, such as the unlimited carryover or grace period amounts from previous relief, any amounts used over the $10,500 limit in that calendar year in 2021 is likely subject to taxation. But even if the employer opts not to allow employees to increase their election limits, if, for instance, an employee has carryover amounts from the previous year that would cause them to have an amounts in their decap in excess of $5,000, say, if they had an unlimited carryover from previous relief, that amount over $5,000 will not be treated as taxable income for the participants. So we can go to the next slide, please. So our next step is, if the employer opts to allow the participants to increase their elections, what should they communicate to the employees? The ARPA does not have within it a notice requirement for these changes. However, if the employer does elect to increase that limit, they should notify the employees of this change. So that's pretty much all we have here for this particular step. And go to the next slide, please. So there is a amending document requirement for this change if the employer opts to allow participants to increase their participation amounts. And go to the next slide, please. Under ARPA, retroactive plan amendments are permitted so long as the plan is amended no later than the last day of the plan year in which the amendment is effective, and the plan is operated consistent with the terms of the amendment. Much like in previous guidance with other relief, if the employer does opt to allow participants to increase their limits, they will have to amend their documents. They can do it for retroactively, but they need to communicate to their employees that the change is going to be permitted, the elections will be increased, so that they can act consistently with the terms of that amendment. Now, if the employer is considering increasing these limits, there are a couple of practical considerations that they need to take into account. First of all, if you increase the employee election amounts in the decaps, this could negatively impact an employer's non-discrimination testing. Now, as you may know, DCAPs tend to fail some non-discrimination tests because it turns out that usually your highly compensated employees or individuals are the ones who benefit the most from this particular benefit, and that tends to fail the benefit test. And if you increase the election amounts in the DCAP, you might run the risk of actually making that problem worse. So that's something to be aware of. Second consideration is if the plan document indicates a 5K limit and the employer allows elections in excess of this, the documents need to be amended. This includes, as I mentioned here on the slide, the Section 125 cafeteria plan document. And employers will need to work with vendors to implement any changes and monitor testing results if they do elect to make this change in their DCAPs. These are not insurmountable problems, but certainly there are some opportunity costs and some additional costs that could be inherent in making this change that employers should keep in mind if they are considering making this change. So I think that wraps up the section on DCAPs. Are there any questions on this before we move on to that little known part of ARPA about Cobra subsidies?
Yeah, that minor thing.
I think you explained it so well, Patrick. There's not very many questions, but there is this repeated question that we have been getting over these last several weeks on whether or not these changes are optional for employers.
And we're talking about changes, we're talking about the DCAP changes?
Yeah, whether it is optional for an employer to increase the contribution amount to that $10,500.
Yes, I believe that it appears that ARPA makes that an option for the employer.
Right. I concur.
Nice. Concur. So now moving on to the main event. I'm sorry that I don't have main event. Some kind of fight song here. So Cobra basics, just the basic of ARPA. ARPA provides that certain Cobra participants, they don't have to pay their Cobra premiums from April to September 2021. That's it. That's it. So it sounds so easy, right? No. So that's why you're on this call. It's not so easy because then we get into all the little details of how this has to happen. So step one under Cobra, identify plan type. So who is responsible for providing premium relief to participants and claiming the tax credit? Who has to suit up here and get ready? So if you are a fully insured employer subject to federal Cobra, that's going to be you. That's the employer. What about if you are a self-insured employer plan sponsor subject to federal Cobra? Still you. If it is a single employer plan subject to state continuation, not federal Cobra. So a lot of times when we think about this, we think, oh, the small plans, not subject to Cobra, less than 20. Remember, this could be a church plan too. So if you're a church plan and you're not subject to federal Cobra and you're subject to state continuation, normally if you are fully insured. So that's going to be the insurer. But don't think if this is your category that you don't have any responsibility. You'll see on the next steps 2 through 6 that even if you are that small employer or that church plan subject to state continuation and not federal Cobra, you still have some responsibility in identifying those assistance eligible individuals, sending notices. So really still you. And then on the multiple employer welfare arrangement, MEWAs, including PEOs, no guidance on that, but you will have to look at how that MEWA, multiple employer welfare arrangement, is structured. MEWAs can be operated or maintained on the plan level, meaning that there's one plan document. Everyone is treated on the aggregate. They are rated on the aggregate. In that case, it will most likely be the plan that is responsible or the trust or however that's operated. for filing for the premium tax credit and providing the premium relief. However, if you have a MEWA where the rating is look-through, meaning that each employer receives their own rates in a MEWA and that there are separate SPDs, that most likely will be the employer. So look at your SPDs, your summary plan descriptions, and look to see who is named as the identified plan administrator and plan sponsor if you're part of a MEWA. And I realized I skipped one. I skipped the multi-employer plan. This is different than multiple employer. I know we have so many terms in benefits compliance. A multi-employer plan is a union plan most of the time. And that is going to be the plan, the trust, the union who is responsible. Okay. Subsidies apply. So again, plan type, subsidies apply to medical, dental, vision, HRA most likely, because the law references and the guidance references group health plan. ERISA and Cobra, medical, dental, vision, HRA, and EAPs, if they provide significant medical care and you're offering Cobra on them on an EAP, most likely HRAs and EAPs will be included, but for sure medical, dental, and vision. The law specifically excluded health FSA. Now you're offering Cobra for your health FSAs on your underspent accounts, but they are not going to be eligible for the subsidy. Okay, step 2 for Cobra. Step 1, identify your plan types. Step 2, identify your AEIs, and that's a new acronym we have. AEIs stands for assistance. Oh, not assistant. I'm not hired. Maybe I need to hire an assistant. Assistance eligible individuals. We'll fix that before we send it out. And initial Cobra triggering event has to be involuntary termination of employment. And yes, that includes termination for performance. We'll talk about that in a minute, but whenever we say that the reason they initially lost coverage had to be involuntary termination of employment, the very next question people ask is, well, what about gross misconduct? So let's kind of take a step back and talk about gross misconduct. Gross misconduct is a specific exclusion to offering Cobra in the first place. So if someone does gross misconduct, and there's really no definition of that, it's been defined through hundreds, maybe even thousands of case law. And is it, there was even a case where someone worked for a grocery store and they stole a cake from the bakery. Is that gross misconduct? There have been cases where employees beat up their boss. Is that gross misconduct? So it's a complex area of the law, and denying someone their Cobra rights in the first place, we never think of that lightly, and you will want to consult with your legal professional, your outside counsel on this if you are to deny someone their right to Cobra. So obviously, if you are doing that after advice of counsel, then no, they're not going to be eligible for the subsidy because you're not giving them Cobra in the first place. Quick little state reminder here. New York State continuation applies to gross misconduct because New York State continuation says it applies when someone is not eligible for federal Cobra. So gross misconduct is a reason to receive state continuation in New York. Reduction of hours. This is a clarification we went over last week, but in case you weren't here or missed it, reduction of hours is both involuntary and voluntary. So if you had a situation where someone is on a leave of absence, they're not terminated from employment, it's a leave of absence, and they have lost eligibility due to the terms in your plan, then they are going to be eligible for this subsidy if they meet the other conditions. And I do have a furlough example on the next slide because we've had a lot of questions on that. So number 2, so number 1 is what is the triggering event? Why did they lose their coverage? 2, They have to still be in their maximum coverage period. 18 months for federal Cobra coverage generally. So people have been talking about the look back to November. We're unsure if it would include the 29 months for employees who were on disability extension, if we have to go back to the 29. State continuation varies. New York is 36 months. Other states are 3 to 9. And don't forget, this includes new Cobra qualified beneficiaries as well. So we keep thinking about, oh, we're looking back to people who were previously terminated from employment involuntarily, or somebody who just reduced their hours. This is for coverage April through September. You could have new people that qualify for this. This includes them. So any of the assistance eligible individuals that are April through September. Does anyone on the team, because our team is on the call, or Patrick, do you want to mention the kind of issues with the state continuation or the question mark I have there for the employees on the disability extension?
Well, we often get questions regarding whether or not employers need to look back farther than, say, October 2019 in order to determine whether or not a person would qualify for the subsidy. And often this question is predicated on the fact that state continuation laws often extend the coverage period, essentially, for Cobra beneficiaries. So we get that quite a bit. Is my understanding from the guidance that you only need to go back to October of 2019 in order to determine whether or not somebody qualifies, but the extensions might come into play in situations where, for instance, a person has been on the federal Cobra and that maximum Cobra coverage period ends, but the state continuation period continues, because the subsidies will cover state continuation premiums. And it was provided that that ends in the middle of the Cobra subsidy coverage period from April through September. That could be an issue.
Yeah, it's confusing because so many people have latched on to that date of looking back to a certain date. And I know we get that question a lot, but state continuation would vary on the length. And hopefully we'll get some greater guidance, more specific, geared towards employers pretty soon. And then the third and fourth condition for being an assistance eligible individual AEI is they are not eligible for other group coverage and they're not eligible for Medicare. Now, a question that we have received quite a bit is Medicare doesn't cover dental or vision. So if someone is eligible for Medicare, does that knock them out of assistance for dental and vision Cobra premiums? That's our understanding. Again, it's one of those things that doesn't seem fair, but things aren't always fair. And so it's a condition of being an assistance eligible individual. It goes back to how that term was defined in the law, and it says not eligible for Medicare. So even though they don't have dental and vision coverage, most likely they are not going to be eligible for any kind of Cobra subsidy. Okay, moving on. And that, just to touch back on the performance. So if we're talking about someone who was let go for performance, not gross misconduct, and maybe they were always coming in late or they were always late on projects, they are going to be eligible for this. And I know it doesn't seem fair. Again, they were fired for performance. They're going to be eligible for the subsidy because that is an involuntary termination of employment. We get a lot of questions about furloughs. So here is an example that hopefully will help you frame this. And furloughs can be lots of different ways. That's a term that may mean something to different people. So Central Perk had to close temporarily because of the pandemic. It's a coffee shop in New York. They had to close. Rachel and Gunther are furloughed. They lost coverage May 1st of last year, 2020, under the terms of their plan due to reduction of hours. So this is an important point. Their plan document said that when they were no longer working full-time to part-time or furloughed, they lost coverage. So they were no longer eligible under the plan. They were offered Cobra for reduction of hours, the qualifying event, and they never elected, neither of them elected Cobra coverage. They were notified this year, March 1st, ready to come back to work. Hey, we are open again. Come on in for business. And they called Gunther and Rachel and said, get back to work. Gunther was happy. He returned, and his active coverage will be effective April 1st of this year. And Rachel said, see ya, I'm off to Ralph Lauren. I got a better job opportunity. I'm going to Ralph Lauren to work. So questions. Did Rachel initially lose coverage due to reduction of hours or involuntary termination of employment? Because remember, on our previous slide, that is the first condition of being eligible for the subsidy. Was the triggering event reduction of hours, voluntary or involuntary termination of employment? It is. It's reduction of hours. It doesn't matter whether or not she returned to work voluntarily, involuntarily. That's not part of the analysis. The analysis is, did she originally lose coverage due to reduction of hours? Yes. Is she eligible for the subsidy effective April 1st? Yes. If she isn't eligible for coverage from Ralph Lauren, she said, hey, I'm off to Ralph Lauren. If Ralph Lauren offers her coverage, remember, if I'm eligible for other group coverage, I'm not eligible for the subsidy. But how does Central Perk know if Rachel is eligible for Ralph Lauren's coverage? They don't. They send the notice, which we'll talk about in the next step, and Rachel will be responsible for self-certifying or reporting that she has other coverage offered to her. Severance, we got lots of questions about this last time too. Just going to give you some parameters here on severance. It's not a one answer fits all situation for severance. It can be structured so many different ways based on the circumstances of why that person is no longer working for you, on your severance agreements and the language you put in them. For example, let's consider an executive type employee who's being let go, and but the employee wants to, save face. They want to manage perception of how everyone sees them. And so they mutually agree, the employer and the employee, for him to resign. Is that voluntary or involuntary termination of employment? The employer, if he didn't resign, they were going to fire him. They were going to let him go. So you can see how the lines get blurred, and we can't answer that question for you. We can't say how you want to label that involuntary termination or voluntary termination of employment. So on this issue, we're going to have to advise, seek outside counsel, and then they can look at the exact set of circumstances and the language of your severance agreement. One final little tip here. If you have an agreement where you're maybe conditioning a Cobra subsidy on a certain action, sometimes, for example, let's say, hey, Jane, you agree not to take legal action on a certain issue, or you agree to X action, you won't take these certain clients, whatever. And if you agree to that, then we're going to subsidize your Cobra for 6 months, the employer is. You would really want to take that out and look at the language on that for the period from April to September, because you do not want to give the impression to a Cobra beneficiary that they have to meet other conditions, additional conditions, in order to receive a federal subsidy that they're entitled to. And then still continuing with who's an AEI, what about spouses, dependents? Yes, it appears that employee spouses and dependents who lost coverage due to the employee's reduction of hours or involuntary termination of employment would be included as an AEI. That means that their family premiums would be subsidized, and they would have an independent right to elect coverage from the employee. This does not include, so assistance eligible individuals does not include spouse and children who lose coverage due to employee's death, because that is a separate Cobra triggering event, death of employee. It is different than termination of employment and reduction of hours. So that is not subsidy eligible. Spouses losing coverage because of divorce and children aging off of the plan. They are offered Cobra, but they would not be eligible for the Cobra subsidy. There's been a question, what about spouses and children that are still on Cobra now? They're in their 36 months, maybe they're past the original 18, because the original event was involuntary termination of employment, but then they got a divorce or the employee died, and that's a secondary event, giving them the extended 36 months. There's just no guidance on that situation. And it goes back to what Patrick was saying earlier about looking at the 18 months and going back to November of 2019. So that's just no guidance. Hopefully that's something that we'll hear more on. Okay, I want to pause here for questions. We've only done step 2, but we're halfway through the presentation. And so I want to check in with you, Diane, and see where we're at. Any questions on the steps we've covered, assistance eligible individuals and plan types?
Yeah, there have been a few questions, and I'm sure you'll be able to clarify when we're referencing looking back to that October 2019 or November 2019 to identify those who might be assistance eligible. There's some confusion on why we would look back through October 19, or some folks have seen November 2019. So do you want to explain the nuances there, or I'm happy to?
I would love for you to.
So if we are looking back to find folks that are in their maximum Cobra coverage period, you can look as far back as October 2019, where the Cobra triggering event may have occurred, where oftentimes when you, let's say, have a termination of employment October 15th, 2019, but per plan terms, coverage will remain through the end of the month. So my loss of coverage, or that individual's loss of coverage, wouldn't happen until November 1, 2019. So when the reference being back to October 19 is really that the triggering event that very well could have occurred in October that created the loss of coverage that happened in November, which would put somebody still in their Cobra maximum coverage period.
Perfect. Love that. Yes. Because we're talking about, are they still in their maximum Cobra coverage period? That was one of the conditions we looked at. And so if we're saying 18 months, we're looking at when did the Cobra coverage period begin? And that could have been based on a triggering event that happened in October, because lots of plans, almost all plans, have coverage through the end of the month.
Right,
Okay,
right.
Thanks. Anything else you want to bring up?
Well, and another question that I thought was interesting, and we've seen it several times, is, hey, if we know that an assistance eligible individual is eligible for other group coverage, but they're taking advantage of the subsidy, what's the employer obligation in that instance? And I don't know.
Great question. I mean, sometimes the carriers will know because the carrier is covering them under another plan as a dependent, and it's triggered, or the carrier knows that they have been coordinating under active coverage for Medicare. But in general, you may know they're working for another employer. You may not know whether or not they're eligible for the coverage.
Right. And so I think we're just waiting, hopefully, for a little bit more IRS guidance in this instance, I would think. But to your point, this responsibility really lies with the individual, with the guidance that we have now on not electing coverage if they're not eligible. And as folks may know, those individuals receiving the subsidy are when they're in fact not eligible or not informing the employer of the fact that they're eligible for other group health plan coverage, they're subject to penalties.
Yes, and the penalties are described in the notice, which is step 3. So step 3 is send notice number 1, which I'm calling it, to designate it from notice number 2, which Patrick will be talking about. And it's the subsidy availability and special election period notice. So what does this notice do? It notifies the AEIs of their right to receive the Cobra subsidy. So it talks about the Cobra subsidy availability, the right to receive it, their right to elect Cobra effective April 1st. If they never elected Cobra to begin with, like Rachel and Gunther, or they previously dropped Cobra. So let's say Rachel paid for Cobra for a few months and then she stopped paying for Cobra and she had a gap. So both of those scenarios, they have a right to come back and elect Cobra coverage effective April 1st. And so those two things are a requirement for the employer. Those are not optional. But the third is optional, switch coverage options. So it's an option for an employer. You could allow an AEI to switch plans. Normally we think about Cobra, they can continue the coverage they had originally. But this would allow them to switch coverage options, but only to a lower cost plan option. So if I am on, say, a lower cost HMO plan, that's what I had as an active employee. Now I can't say, oh, government is footing the bill, I'm going to have the upgraded PPO plan. They can't do that. You could do it in the reverse. The employer could say, if you have the upgraded PPO, you could switch to the lower plan. Now, this is an employer decision, optional again. And if you're going to do that, there is additional forms, a section that the employee would need to fill out when they return it. And you would want to talk to your carriers about that as well. And then this notice also gives them instructions and forms for claiming those rights. And as Diane mentioned, it tells them their obligation to notify the plan if they are eligible for Medicare or other group coverage. And it scares them by telling them the penalties if they fail to do so. Who does the notice go to? The AEIs, which we identified in the previous step, who were currently on Cobra, and those who never elected previously dropped. QBs, not quarterbacks here, they are qualified beneficiaries. That's what we call the Cobra participants, another term. It means something very specific. It means the ones that were covered on the plan the day before the triggering event. If QBs are known to have separate addresses, send separate notices. So if you know that a child who was covered under the plan the day before the triggering event lives at a separate address from the employee, send notices to the addresses that you have. So go by the last known address. If it's returned, that with a forwarding address, as it does for a certain number of months, we send it to the new address. Who's responsible for sending the notice? The named plan administrator. Who is that? Well, if it's a single employer plan, it's going to default to the employer plan sponsor plan administrator. Think back to the Cobra Kai slide we had earlier, gearing up. This is going to be the employer plan sponsor, you, for MIWAs and multi-employer plans. Check the SPD Check your plan documents to see who is the named plan administrator, plan sponsor. Of course, you can contract with a third party, such as a Cobra vendor, to send these notices for you. I would venture to say that the majority of our clients are going that route. Or if you were in that category where you're not subject to federal Cobra, you're going with state continuation, the carrier could be sending out the notices, but that doesn't mean that you have no responsibility. A carrier is not going to know most of the time, and the Cobra vendor is not going to know what that event is. They just know this person is on Cobra or was offered Cobra. So you're going to have to work with them, look back in your records, and identify the assistance eligible individuals for that Cobra vendor or the carrier if they are assisting you with the notices. Because ultimately, it's your responsibility. If these notices don't go out, there would be a penalty just like any other Cobra notice not going out, and that's going to come back to the plan administrator, not the vendor, not the carrier. So get involved, do your due diligence, oversee the process. What is this special election? You said that people that dropped coverage can come back. That's right. Second chance ahead. So the AEIs who never elected Cobra or dropped Cobra at some point, they get a second chance. And they can come back and have coverage effective April 1. Yeah, this means that some of them will have a gap in coverage. If Rachel is not offered coverage through Ralph Lauren, or at least that's what she tells us, she can come back April 1 and have coverage paid for with the Cobra subsidy when she didn't have any coverage for the previous 11, 12 months. And if she wanted to have that coverage, quick note, if she wanted to have the coverage from May of last year through March of this year, then she still has that right, because remember, at this same time, lots of laws in play. The outbreak period relief is still in play, and she still is within a year of her Cobra election period for that coverage. If she wanted coverage for May through March, she can still elect that, but she would have to pay retroactive premiums for all of it, and that would not be subsidized. That would be at full price. We already talked about, can they switch plans? Yes, to a lower cost one. We already talked about QB spouses and children have independent rights. The spouse of an AEI, they are an AEI as well, and they could have coverage subsidized even if the employee is not. Maybe the employee has other coverage and they're not eligible for the subsidy. The spouse doesn't have any other coverage offered to them, and so they want the subsidy. Can they add new spouses and children that weren't covered by the plan the day before the Cobra triggering event when they were back as an active employee? This goes back to normal HIPAA special enrollment right rules. A Cobra participant always has special enrollment rights to add newly married spouses and children. So they could add those children if it happened during the Cobra coverage period. But, and I'm jumping out here, alerting my team if they want to listen up. But my understanding is that if they added someone, a new spouse or a new baby, are the premiums for those newly added dependents and spouses eligible for the subsidy? I'm thinking probably not.
I don't think so either, but hopefully we'll get some guidance that addresses that.
Yes, I like to put the qualifiers in there. So that's why it says likely not eligible. I stole this from last week's presentation. These are just a list of the notices, a good reference chart. I've referenced it this week myself. It's really helpful. So for those new people that are having qualifying events occurring April through September and they're assistance eligible, then the regular notice has been revised. The model notice in connection with extended election period, this is the notice you're going to be sending to AEIs. The model alternative notice is for the state continuation plans. And then this summary of Cobra premium assistance, that also has to go to AEIs. So they're getting two things. They're getting the model notice in connection with extended election period, even if they're already on Cobra and don't need to elect Cobra, they still get that model notice, and then they get the summary at the bottom. Okay, so this, what does a QB need to do if they get this? Those currently on Cobra and claiming the subsidy. I'm already on Cobra. Do you give it automatically to everyone? No. If someone wants to claim the subsidy, they have to return the form. They have to complete the request for treatment as an assistance eligible individual found on page 2 of the summary notice. This is what it looks like. What if I'm not currently on Cobra? I want to elect Cobra and I want the subsidy. Well, then they have two things to do. They have to fill out the previous form on the previous slide, the request for treatment as an assistance eligible individual, indicating that they are not eligible for other coverage. And they also have to fill out the Cobra continuation coverage election form found on page 6 of the notice of extended election period. I know that is a lot of words, and you will get a copy of these slides, but remember, if they are not currently on Cobra and they want to elect Cobra and they want the subsidy, they have two things to fill out. Whew. Here are your important dates. You have to send these notices to Aeis by May 31st. Those of you that are good with dates know that this is Memorial Day. It is a holiday. They do not deliver mail on Memorial Day. So without guidance saying that they are extending the deadline to June 1st, we're going on the conservative route and saying that you need to make sure that those notices are postmarked on or before Saturday, May 29th. They have 60 days to elect and postmark their return forms. So this means if you're sending them out in the middle of May, they have until the middle of July to elect coverage, and then it would go all the way back to April for the coverage. It would be retroactive. Whew, okay, I'm going to take a break talking here. It's all yours, Patrick.
Good job, Jill. You have the eye of the tiger. And now we're going on the highway to the danger zone. The premium payment process for the Cobra subsidy. This is an area I think we're going to be needing some more guidance on, but this is what we know so far. Employers should work with the carriers and their Cobra vendors in order to come up with a process for paying the premiums. But there are a couple of things to keep in mind. First, Aeis should not be charged the premiums for April through September. They are considered to be paid in full. However, this will depend upon the Aeis completing and returning the form that we just discussed earlier, the treatment as an assistant eligible individual form. And the entity responsible for paying the premium is entitled to the tax credit. As Jill had mentioned earlier, just to refresh, the carrier for a fully insured plan that is not subject to federal Cobra, the employer for all self-insured plans and fully insured plans that are subject to federal Cobra, the plan for the multi-employer plan, and then note that an employer with a fully insured plan subject to Cobra will likely have to front the premiums to the carrier for assistance eligible individuals and then will receive the credit. So we think that will probably end up happening. So if we can go to the next slide, please. And now we'll talk about the next notice, or rather the last notice that's in the Cobra subsidy process. And if we can go to the next slide, please. This notice is the notice that you send at the end of the subsidy coverage period. And this notice notifies the AEI that the Cobra subsidy will soon expire and also provide the exact date that the subsidy will end. And in addition to that, it provides AEI's information concerning eligibility for coverage without any premium assistance through either Cobra continuation or coverage under a group health plan. It should note that the AEIs and any covered dependents may be eligible for a special enrollment period to enroll in individual market health insurance coverage. And this notice has to be provided 15 to 45 days before the end of the expiration of the Cobra subsidy. It's not required, however, if the AEI becomes eligible under a group health plan. And that excludes, by the way, accepted benefits, a QSE, HRA, or a health FSA, or if the AEI becomes eligible for Medicare. We're not sure if a special enrollment period will be established in the marketplace for people who are on the Cobra subsidy. We kind of think that that may happen. There's certainly a special enrollment right for those people who had been subsidized by their employers in the past, and then the subsidy ends. They usually get a special enrollment period. So we kind of expect one here, although we haven't seen anything official come down yet on this, but we suspect that might happen. But in any event, the notation that they may be eligible for it should be in that particular notice. So we go to the next slide, please.
Before moving on, one question that we got a lot from last week was, what if someone's maximum Cobra coverage period is ending, say, in April or May? And so remember, this does not extend their Cobra. If my 18 months is up at the end of April or the end of May, then this doesn't extend the time I can be on Cobra. So you're sending me this notice 1, the one that I went over, and then I would be getting notice 2 around the same time, because you're saying it has to be sent 15 to 45 days before the date of the subsidy when it would end for me. This is an individual analysis, right? Not just everyone gets it in September.
I think that's true. Yes, I think that's right. So
I could be getting it at the same time. So I'm getting a letter that says, hey, you're eligible for a subsidy. Your Cobra ends in May. And then I would get notice 2 that says, hey, your subsidy ends the end of May. So yeah, this could be the same time. The guidance does say you can't combine the notices, and what we think that means is that an employer couldn't say, or a vendor couldn't say, you know what, let's save postage and let's send out notice 1 and 2 May 1st and just, hey, this is when your subsidy ends. No, it still has to be provided. Notice 2 has to still be provided in that 15 to 45 day time frame. But some of these people will be receiving it in the same period of time, April, May. So we think you should still do 2 separate notices, but we're thinking, unless they tell us otherwise, you could put them in the same envelope.
Yeah, hopefully we'll get some more guidance on that issue. All right. Now, the next step in the Cobra subsidy process is how to apply for the payroll tax credit. And boy, do we need guidance on this one. Hopefully we'll get some guidance from the IRS on this soon. But for now, what we know is that the credit is calculated each calendar quarter in an amount equal to the premiums not paid by qualified beneficiaries who qualify for the subsidy in that quarter. We also know that the credit is limited to the amount of the FICA tax, and any overpayment must be refunded. However, a credit can be advanced through the end of the most recent payroll period in the quarter. The amount of the credit equals the amount of the premium plus the administrative fee. So it's usually that total of 102% of the cost of premium, as per normal for Cobra premiums. If the employer pays more in Cobra subsidies than it owes on employment taxes, then the IRS refunds the difference. So for example, if Central Park has to pay for Cobra for 10 Cobra qualified beneficiaries, and each one of those costs $1,000, so that they would be out of pocket $10,000, but they only owe $4,000 in employment taxes for that quarter, then they not only do they not have to pay the $4,000 in employment taxes, they also get $6,000 cash back from the IRS to reflect that other $6,000 that was paid out in order to cover that subsidy. So that in this way, the employer is not out of pocket at the end of the day for the Cobra subsidy. Are there any questions about this step? I mean, to the extent that we have any guidance on this.
Well, before we pull in Diane, I know a question that we've gotten a lot is, so I'm an employer, and if I am contracting with my Cobra vendor to send these out, there's going to be an additional cost to that. We've only heard, well, I don't know if we've heard of any that weren't charging, maybe one regional, but most of them are going to charge. This is an additional service that they have to provide, postage. And would an employer, when they get the payroll tax credit, are they going to be able to get a credit for all of their administrative costs and fees, postage, et cetera?
Well, again, I don't know if we have any clear guidance on this particular issue, but an argument can certainly be made that they would be considered administrative fees for this purpose and could be included. But again, I couldn't say that there's clear guidance on that for certain.
Yeah, agreed. I concur. Yeah, it says administrative fees, but does that just mean the regular 2%? Because that's what the 2% usually is, administrative costs. So what if, the additional burden of sending these out, is that if it exceeds 2%, are you going to be able to get that back? We just don't know. It's one of those issues that we hope is clarified soon. The guidance that we received was more geared towards, it was the notices, but also it had FAQs more employee-based rather than employer-based. So we're hoping when the IRS comes out with some guidance that they will give us some more information.
Indeed. And similarly, in cases of the disability extension where you can charge up to 150%.
Yes.
There is no guidance about that directly addresses that. But again, it seems likely that the argument can be made that those would be administrative fees that can be included in the subsidy.
Yeah, it is, yes, because 50% in that case is administrative fee, and that's a lot.
Right.
But yeah, so there is going to be a cost associated with this when you think about a self-insured plan specifically. So you're getting a payroll tax credit for the premium amount and an administrative fee, whether it's $250 or whatever they're going to give us. You still have the claims costs. Those aren't reimbursed. And then for a fully insured plan, utilization is going to hit the plan, which could affect rates for the next year. But yeah, Diane, if we could get some questions, what are you seeing?
Oh boy. Okay, Patrick. Patrick, we had a request, if you don't mind reiterating what you had explained, and maybe Joe, go back to the previous slide, if you will, on the credit advancement. Mm-hmm. So I think it's the third bullet. If you just don't mind reiterating that, I think inquiring minds are listening.
Well, again, since we don't have a lot of guidance on this particular issue, I'm not sure how much farther I can carry this ball, but the ARPA does allow credits under this program can be advanced through the end of the most recent payroll period in the quarter. How that will be implemented in practice, I think, is still open to question, and we haven't gotten any guidance on that.
Right.
Yeah, it's tough. That's going into tax advice, which is out of our realm. But yeah, if there's going to be a cash flow problem and there is something, with an advanced tax credit, that's certainly something you would want to talk to your accountant about.
Right. Yeah. And I think just to reiterate what Jill just said is a lot of this issue definitely seek guidance from a tax advisor. The other question we received a couple different ways is what documents should employers be retaining to support, if you will, the tax credits. And I'll give my 2 cents on this, and Jill, Patrick, feel free to chime in. But, we're waiting on further guidance from the IRS on the exact process or additional information on the process. But at minimum, employers are going to want to keep a record of those employees or former employees who are receiving the subsidy and for how long. Do you guys have anything else you want to add there?
That's pretty much in line with what I would suggest as well. Again, this is going to be something we're looking forward to seeing from the IRS as to what they're going to want to see when the employers ask for the credit, or whoever's fronting the premium is asking for the credit.
Yeah, and I mean, remember these are federally funded subsidies. So when money comes that way, the IRS wants to make sure that it was spent in a fiscally responsible way. And so I think any effort you can make towards documentation of how you decided someone was an assistance eligible individual, including the forms, of course, that they send back to you, but even in that first step 1 and 2, how you're determining who was involuntarily terminated from employment, how they originally lost coverage, how does your terms of eligibility work? Any of that documentation is going to be helpful.
I concur.
Yeah, agree. Yeah.
I love it.
Sold. And one participant chimed in with a suggestion on invoices or any sort of similar documentation that can just help for the amounts of subsidies for record keeping.
Good suggestion.
Switching gears onto a different question, and we received several times, is with this second chance or second bite at the apple in enrolling in for those assistance eligible individuals who did not initially enroll or dropped coverage and are still within their maximum coverage period, if they choose to now enroll during April 1 through September 30, what happens if that group health plan that they were enrolled in no longer exists?
Oh,
Nice.
Yeah, that's awesome. So, dun, dun, dun. Well, this can be like a cliffhanger at the end of a season of a TV show. I will say, we can all chime in with answers. I would say, Cobra says, Cobra obligations cease for an employer when they fail to maintain any group health plan. So you have to look at who's the employer. If it's a controlled group situation, main employer, any subsidiaries, is anyone still in that single employer in the control group? Are they still offering any other plan? If so, I would say they have a right to elect coverage under that plan, still with a subsidy. Go.
I concur. I agree with that, and maybe bounce this off of you guys as well. If there are multiple plans or a different plan, it would be the plan most similar, perhaps, to the plan that did exist that doesn't anymore.
Yeah, and if there is no plan, if the employer doesn't have a plan anymore, then the obligation to offer Cobra ceases, and if there's no Cobra, there's no subsidy.
Indeed. In absence of further guidance on this, I would say the analysis would be the same under normal Cobra circumstances. The only difference here is who's paying for the premiums.
Yeah.
Yeah. Okay. Very well. Shall I keep going?
Yeah, we can take one or two more.
Okay.
Bring it.
This question was asked a few times. And I know we talked about it, but because I think the confusion that it elicits, perhaps we can reiterate severance. So, Jill, I think you discussed this issue, and I apologize if that was Patrick. We have been busy answering 200 questions, as you can imagine, but it's voluntary termination with a severance. And in this particular question, and we've received it at least 3 times, and we've received it much more in the past couple of weeks than that. Involuntary termination with severance, and the severance agreement has terms where the employer is paying Cobra for X amount of months. Several questions come from that. Is the employer still able to claim the tax credit? Is really what comes to mind. And I can give my 2 cents, and if you folks want to chime in, or
I have an opinion. I have an opinion, but I want to hear yours first.
Okay. So my thought in that is it's not exactly straightforward. And off the bat, we would recommend, when you're dealing with the terms of a severance agreement and how the Arpa subsidies might impact that, we would recommend a conversation with counsel. But the thought is while the employer might likely be able to be reimbursed for those subsidies, there could be nuances in the language of the severance agreement that could hinder that. So, for example, or not hinder the ability for the subsidy, but the employer could have still obligations to the employee depending on the terms of the severance. So, Joe, I would love for you to chime in on that, or if you have other thoughts or differing thoughts or what have you.
Yeah, my thought is the clearer the communication, the better. So some things in our world, in the benefits industry, make it to mainstream. And a lot of people understand that there are Cobra subsidies available. Like, I have family members or friends ask me because they've heard about it. And so in your severance agreement, if the language is saying you get 3 months paid for of your Cobra premiums, what does that mean? You don't want there to be, misguided information where they're hearing they're eligible for 6 months of a federal subsidy. You've got 3 months coming from the employer. Oh, do I get 9 months? So after my 6 months from the federal government, you're going to give me 3 more? Or, oh, you mean I only qualified for 3? I thought the federal government was giving me 6. Very clear terms in that agreement.
Yeah, I like that.
Yeah, the only thing I'll add is I'll just reiterate that it's very important that the employer talk to counsel about the terms of the agreement, how it will impact. I can't emphasize that enough. There are other issues that also might be at play here, as for instance, the severance agreement may only cover certain kinds of coverage that could be covered under Cobra and not all of it. And so how does that get worked out? There are also other attendant issues like that would need to be discussed.
Exactly. Yeah, I agree.
Okay, well, we can give people 10 minutes back in their day. If we want to wrap up, up to you guys.
Sure. I know I speak for all the attendees, and thanks for sharing all of this information. It's still something that we're working through. So thanks, Patrick and Jill.
Yes, and we have lots of resources for you. We have the previous archives. We have some FAQ documents that we've done. Check out Compliance Corner article that was yesterday. So lots of resources for you. We try to get to all the questions, but I think there were over 150. Is that correct?
Yeah, I think right now we're at about 210 questions.
Okay. So, if your question does not get answered, please refer it to your advisor, your consultant, and then we are happy to help in the coming days. So you want to take us out, Leanne?
You got it. Thank you, Jill, and thanks, Patrick. And want to extend a big thank you to our entire benefits compliance department for managing the Q&A. I know there were a lot of questions today. We got too many of them. We really appreciate you guys sharing your valuable time and expertise with us. And as a quick reminder to all of our attendees, today's presentation was recorded and will be emailed out tomorrow. The recording and the slide deck from this webinar will be posted to the nfp.com latest insights page under webinars and trainings. That concludes our webinar for today. Thank you all so much for joining us and have a great day.
Thank you, everybody.
Thank you.